Good afternoon, everybody. I see we have some audience here today. That's great. My name is Neil Kalin. I am joined, as I am almost every month, by Michael Simkin, and we are from the Real Property Law section of the California Lawyers Association, ready for our monthly case law update. Right, Michael?
That's right. Always something to
Okay.
learn.
Always something to learn. Wonderful, wonderful. Good. So we call ours What's Up With Us because we give you information about recent cases, sometimes recent statutes, and we always like to end with a little bit of information about the real property law section and what we have coming up that you might be interested in. So let me get us going. Change my slide here in just a second. Do you see today's agenda, Michael?
Yeah.
Okay, good. So what do we have today? We've got 3 federal cases. We've got 2 state cases that we're going to talk about. We do not have an interview today, so we're going to be going straight through the cases. One, a U.S. Supreme Court case, Sheets versus County of El Dorado. The other one, a state appellate court case, Vichy Springs versus Ukiah. Then we have People versus Freetown, which I thought was interesting. When is an owner responsible for criminal activity inside and outside of their own property? In Ray McKee, dealing with homestead protection in the context of a bankruptcy case. And then Tucson versus Seattle, which is primarily a First Amendment case, but it reminded me of something that I think would be of interest to a real property practitioner. So we'll get to that at the end. Let's find out what's up with us today. It's rare that we have so many federal cases. So let's start up. We're going to start off with a poll if we can get our poll running. So I'll just read the question. This question is, since we got all these federal cases, what is federalism? And we've got 4 choices for you. A political system where all decision-making belongs to the federal government. A political system where all decision-making belongs to the state or local authority. What do you know? Thank you, Brooke, for getting our poll up. So anyone who's watching, vote as soon as you have a decision. A political system where some powers belong to the federal government and some to the state or local authority. And finally, a political system where title to land is held by a lord, and those who work for the land are mere vassals. So what do you think is the right answer? Doing pretty good. We'll give you just a few more seconds to decide what is federalism, and then we'll go back to our screen. How about just 5 more seconds? 4, 3, 2, 1. Let's end the poll and share the results, Brooke. I may have to end it. Oh, you're ending it. Perfect.
We have 81%. Wow.
Okay. So 81% thinks the answer is C, a political system where some powers belong to the federal government and some to the state or local authority. Okay, and a few other answers in A and B, but the overwhelming majority of you are going with C. So let's check it out. Stop sharing. Can we get rid of the poll? Can we get the poll off our screen, Brooke? Is that possible? I hope so. Brooke, what do you say?
Yeah, it should be gone.
I still see it.
Okay. I still see it too. I just clicked on back because I thought that might get rid of it. but it didn't.
Yeah, if you
I checked
exit out,
numbers.
it should be gone.
It's still there. Still have our screen there. Let's see. Ah, okay. It is. I see. Do you still see it, Michael? I got rid of it.
It's still there. I
Okay,
mean,
so you still have the poll, not the slide.
no,
from,
I don't have the poll. I just have the slide.
Oh, okay, great. So the overall majority of you pick C. Let's see what I came up with my little bit of research before our presentation today. And here we go. According to spn.org, I can't even remember what that stands for. Federalism describes a system of government where some powers belong to the national government and some belong to the state government. Absolutely. We're going to see how that is all relevant. So 81% of you were absolutely right. Congratulations. I'm glad to see that nobody picked D, because that is feudalism, not federalism. So let's get into our cases.
I want to bring back some feudalism. I mean,
I just had it up there, just to see if we could trick somebody, but unfortunately, not today. We'll see about the future what's up with us issues. So let's look at Sheets versus County of El Dorado, Supreme Court of the United States case. What happened here? You had a property owner who wanted to build on his property. It was kind of interesting. What did the property owner wanted to build? He wanted to put up a prefabricated single-family residential property. I know I've had some people say, oh, they're talking about a mobile home. Well, there's a difference between a mobile home and a prefab home, but prefab homes are usually pretty inexpensive. So the property owner wanted to put up this prefab home. Of course, applied to get a permit, and what happened was charged a fee of $23,420 as a traffic impact mitigation fee. Property owner wasn't too happy about it, but the owner paid the fee, got the permit, put up the prefab home, and then challenged the fee afterwards as an unlawful exaction or a taking in violation of the United States Constitution. Lower court decisions, well, the California Superior Court sustained the county's demur and said that, well, guess what? We've got these case laws. The preeminent case law in taking two cases are Nolan and Dolan. And the Superior Court says, well, those apply to the conditions that you have to have a nexus between the activity and the charge, and that there has to be some kind of reasonable relationship to what the government wants to do. Lower court says those apply to permit conditions, charges, fees that are imposed by administrators, okay, on a discretionary basis, not something that was imposed by legislation. So the county enacted an ordinance that created fees based upon the type of development and how far the property and where the property was, for example, right? Because the concern in this area was that the population was expanding and that there needed to be proper infrastructure to address the expanding population in this area, the county of El Dorado. So lower court decided, for the government, said, you're saying that you can't charge this, but this is a statutory provision. It's not an administrative fee. The Court of Appeal affirmed. Went up to the California Supreme Court. The California Supreme Court denied review. And apparently this is an important issue for Sheets, and they took it all the way up. They did a petition for writ of cert before the Supreme Court of the United States. They granted the petition and heard the case. And what did the Supreme Court decide? The Supreme Court said, well, we look at the history of the takings clause in the Constitution, and there's nothing that distinguishes in substance whether there's a taking because of a statutory mandate or because of some kind of administrative mandate. Matter of fact, the court went way back and said, historically, takings were always statutory. because the state would come in and try to take somebody's property pursuant to some kind of state law. So the conditions about having an essential nexus, about having rough proportionality, they apply equally in this case as they would have if there was a local agency that was demanding some kind of fee in order to obtain the permit. Now, what did that end this case? I know some people thought this was like some major, huge case, and that this is a tremendous victory, you know, for Sheets. But the case isn't over. All the court said was that the takings analysis applies to your situation. So now it has to go back down to the lower court to say, well, was there an unlawful taking? Knowing that we need to apply the rules, was there an unlawful taking in this case? It could be that the lower court will say, you know what? The ordinance that was in place establishes an essential nexus, right? The county needs to address the burgeoning population within the county. And that fee that was set according to a schedule, well, that's a reasonable fee in light of what we are trying to do. So it's possible that Sheets may owe the $23,420, but at least as of today, Sheets is successful. You know, I put down there at the bottom something I thought that was very interesting. At oral argument, the county waived its position. It seemed like once this got to the Supreme Court, the county said, yeah, you know what? The argument we're making that takings analysis only applies to administrative proceedings, that's really not a valid argument. We're waiving our position. You know, the Supreme Court decided the case anyway, did not declare it moot, right? Wanted to make sure that the rest of the nation understands that takings analysis applies regardless of who the entity is that is trying to enact some kind of fee for some kind of permission. Something else I was very pleased with when I saw this case, I'm like, oh, a Supreme Court case, it's going to be another 50-page opinion. This was an incredibly short opinion, and it was a unanimous opinion from the United States Supreme Court. There were 3 concurring opinions, but there was no dissent. So essentially, it was unanimous. And Michael, what do you have to say about this?
I think this is an example of what I mention often, which is good facts lead to good appeals, bad facts lead to bad law. And this guy had good facts. You know, you mentioned the $23,420. I can't imagine someone bringing this to the United States Supreme Court over $23,000. But from law school, we remember you have a couple of reasons when you get into federal court and to the Supreme Court, and the court mentioned it's just a federal question, and there was a split, you know, in the states about some of these issues here, that where state courts have reached different conclusions on the takings clause and the distinction between that legislative and administrative conditions on land use permits. So I mean, $23,000 is like nothing. So I don't know who was financing this. But you know, that's like our federal civil procedure issue. And like you mentioned, the honesty at the oral argument, I mean, the county said, yeah, we're going to drop that one argument, you know, about the building permits, you know, on the exemption from the scrutiny under the Nolan case. That was very good. And I think that's important in all oral arguments, trial court, and especially at the Court of Appeal, to be honest with the court. I mean, these justices, they've thought about it, they're prepared, and you lose credibility really easily if you start asserting some crazy positions like we see on TV sometimes in New York. So be honest, be practical. That's important at oral arguments. They have some good quotes in this case, Neil.
Yeah.
What was it? Let's see if we came up with the favorite quote. Which was your favorite quote of the case?
Oh my God, I don't, I don't have the case in front of me, Michael, so I don't remember
Okay.
my favorite in this case.
This is my quote for the case. The takings clause's right to just compensation coexists with the state's police power to engage in land use planning. Then in parentheses, it says, though at times the two seem more like in-laws than soulmates.
I remember that. That was good. And I wish I had remembered it 2 minutes ago, so I could have said something when you asked the question. But that's a great case, and that leads right back to our previous screen, right? This is a perfect example of federalism, right? So the Supreme Court is recognizing there's some issues that the federal government is responsible for. There's some issues that the state government is responsible for. So notice there's always some kind of tie-in to our earlier screens here.
And Neil, as you
Anything
mentioned,
else
wait,
before we move
and
on?
Neil, don't forget about these concurring opinions here. You know, you have these these separate opinions, you know, that are carving out possible exceptions in the future. You know, the holding does not include whether the traffic impact fee would be compensable taking if imposed outside the permitting context. Okay. Or, you know, how a class of properties will be treated differently than a particular development. Okay. Or, you know, about or a class of people. You know, we have some of these justices recognizing there's some room here for the future. And it's interesting that they decided to point it out, like instead of just, you know, we didn't talk about it. It's clearly not in the holding. It's not in the underlying appellate issue, but they spelled it out in their little concurring opinions.
And I think little is the key word, Michael, because I think the whole opinion is only something like 8 or 10 or 12 pages, which is just absolutely remarkable, given that there's 3 concurring opinions in addition to the primary opinion. Those of you who are land use attorneys, definitely take the 10 minutes to read Sheets versus County of El Dorado. That's probably all you'll need to get through it.
And then there's another interesting analysis here. There's the whole thing about means to an end and how you know, the end doesn't justify the means. All that, was it Kant, Immanuel Kant's kind of, when they were talking about the relationship?
Maybe one day, Michael, we'll have on, you know, the primary attorneys, because I agree with you, for $23,000, that dollar amount isn't even enough to make it worthwhile to go through the state court of appeal, right? Let alone petition the California Supreme Court, and then on top of that, going all the way to the US Supreme Court. So that might be another interesting discussion for another day.
Yeah.
All right, so what's our next case? Vichy Springs versus Ukiah. And what do we have here? Well, we really have a neighboring dispute between 2 different business entities is really the core or the crux of the dispute here, right? So we've got Vichy Springs. They operate Mineral Springs and Spa in, you know, beautiful Mendocino County. Mendocino County is a area of immense contradiction, right? You've got probably this, you know, almost holistic like springs and spa going on, and what's a half mile away? Well, the Ukiah Rifle and Pistol Club, which operates a shooting range, right? So a lot of stuff going on in Mendocino County. The Pistol Club, kind of an interesting little development here. It's on city-owned land, but the city owns land in unincorporated Mendocino County. So there's all this issue about who has jurisdiction over the use of the land where the Pistol Club is operating. The Pistol Club applied for a permit to demolish their existing facilities and to build new ones, because I guess there's a big demand for, you know, shooting in a proper lawful way in Mendocino County. Vichy was not too happy about that. They sued the city and county, but they, interestingly enough, did not seek an injunction stopping the demolition or the improvement. During the course of the litigation, the construction of the new Pistol Club shooting range was completed. Well, what happened here? The city filed for a motion for summary judgment, okay, alleging that the CEQA cause of action that Vichy Springs was saying should have been used to prevent this development, that it's moot. It said the construction is complete. What do you want us to do? You brought a California Environmental Quality Act cause of action, but everything is done, right? It's moot, case over, judgment for the city, Vichy Springs appeals. What happened on the appeal? Well, the Court of Appeal kind of made an analysis. What's the purpose of CEQA? Okay. And given the purpose of CEQA, can that purpose be accomplished even after the development has been completed? We see there in quotes, we disagree that the claim is moot, right? Because Vichy is saying, well, even after it's completed, there's certain mitigation measures that can be adopted even for the completed new shooting range. And the court winds up saying, well, I guess they're right. There is a way to still enact or take advantage of CEQA to potentially put some limits on what can be done at the new shooting range, okay? They gave some examples there that came from Vichy Springs, right? They could reduce the amount of lead that might be released into the creeks and into the river, which I imagine the pristine nature of those things is what would make people want to go to Vichy Springs, in the first place. So we could do that. We could kind of control the hours and the usage of the shooting range so that there is not so much traffic and congestion and the problems that result from that. And the court says, and part of the defense was, well, wait a minute, you should have raised these things before. You should have asked for an injunction. And the court said, we see no legal basis for concluding that the petitioner's earlier failure to seek injunctive relief requires the court to make a finding that the CEQA claim is moot. Why? Because there's the possibility that there is effective release, effective relief. Something I think everyone should be aware of. If you're reading this case, pay attention. About half of this case is unpublished material, right? So if you're reading this case, I don't know where you get your cites from. You want to be careful. You don't want to be citing to an unpublished portion of this case. Michael's got this grin on his face, so I know you've got something interesting or fun or insightful to say.
Well, it's actually kind of normal stuff here, but I'm like really into civil procedure, and you can see some civil procedure issues here for our educational component. There are two appeals. There are two appeals. Is going to be of the underlying decision, and the second one would have been of the order denying the attorney fee request. And the court, it said it was moot on the attorney fee request because it ended up setting aside. So the appellant has a second chance. If they don't prevail in the underlying case on remand, then they have to, if they prevail, then they deal with the trial court on the attorney fee issue. Because if they lose, they can do another appeal and then see what happens, with that. But I was looking at the other part in here that they mentioned was during the time after the judgment, somebody applied to the attorney general, and a lot of people don't know this, but there are some legal issues that you can petition the Attorney General of California to give an opinion. And they did that in this case. And the opinion, agreed with the ruling, the holding about that the tenant's use of the property, if it primarily serves the public's purposes, that's, the public interest, then there's some intergovernmental immunity. But if the purpose of this lease was to have this private gun club, then that lease is primarily serving the tenant's purpose or the tenant's private purposes, and therefore that intergovernmental immunity would not apply. I think it's pretty obvious, but I'm glad that the appellant ended up getting that opinion from the Attorney General's office.
So those of you out there who do, land use, I imagine this case is not good news if you're a city or a county, right? Because CEQA is such a hindrance to development, intentionally so. But cities need to develop, and they need to, I imagine, try to have some certainty about what can be done once they get a permit and once construction has been completed. And this almost gives those who contest, there seems to be, from what I read, this is not my field of real estate law, but there's a lot of parties out there who use CEQA as an effort to delay or completely try to rid some developments in certain areas. Now, would this give a plaintiff that is trying to hinder development sort of a second chance to do so if they're not required to seek an injunction when the case is first filed? And I'm thinking that cities may not like this because they may have to continue with litigation even after they thought everything was all said and done.
But the injunction that you just mentioned, there's a nice
Yeah.
discussion in this opinion about that. The city was saying it's moot. We already built the place, so we're operating. Guess what? That argument was shot down.
Shut down. Yeah.
And there's a nice discussion in here. I mean, the plaintiff pled injunction as I guess a cause of action or remedy in their pleading, but they never filed the motion for the preliminary injunction. And that's something that's very common. People will put, I want an injunction in their complaint, but they don't do the motion because that motion is difficult. I mean, it's kind of like a summary judgment motion. You have to prove that you're likely to win the case. And this court, they went with it. They discussed it. And I think the petitioner's lawyer or the plaintiff's lawyer, the mineral spa, his lawyer is very smart, very good, because he made a point to point out that there is some post-completion mitigation that could still be done. So all the arguments that, well, we already did, it's too late, too bad. He brought up, well, there are things you can do to reduce lead, reduce noise, do whatever. And that's also the example of good cases get sympathy, and then the court wants to do the right thing and find a resolution here.
And of course, doing the right thing, there's always different points of view on what is doing the right thing. But in an important case to be aware of, it may give life to some lawsuits, and it may give heartburn to entities and those entities give approval to, thinking that it's not over till it's over, right?
Yeah.
Well, normally at this time, we would have an interview with somebody that we think is of interest to real property practitioners, usually somebody that is involved in real estate law in one aspect or another, but we don't have anybody today. So I just thought I'd say, you know what? This could have been you. And for those who are listening today, if you think you are interesting, you think you have something of value to say to other real property practitioners throughout the state, get in touch with me or Michael, and maybe we will have your picture and your contact information on this screen in a future edition of What's Up with Us.
And if I can add to that, Neil, it might be next month. We have a senior title officer that we're going to interview. So you don't have to be a lawyer. It'd be nice if you're involved in real property in one way or another. But we have a title officer, and he's very good, and he's going to be very interesting to speak with. coming up.
Yep, somebody who real property law practitioners may have some contact with or have information that would be helpful to you in your real estate law practice. And that's a perfect example, Michael. Thank you. So what do we have next?
We have the party store.
So here, what do we have? We have a liquor store that was owned for many years, I think decades even. And there's just a lot of criminal activity in and around this liquor store. And you have, in this case, this specific situation here, you had police that had contacted the liquor store owner and were saying, we've got to try to eliminate or at least minimize the amount of criminal activity that is taking place inside and outside of your liquor store. And I have to admit, if somebody goes through this case and they read the case, there was a lot of evidence that was submitted. Michael is really big on this, making sure that one supports their case. There was a lot of evidence submitted about the specific type of activity that was being conducted. There was evidence about the number of shootings that happened inside the store, outside the store, and next door to the store. They had suggestions that were made to the owner of ways to try to minimize the activity. So one of the examples here is maybe they could close a little bit early. Another example here is that they were selling, and I like this, alcohol in cheap single-serving containers. So I don't know, I go to my local Ralph's and I see you could buy a glass of wine, one glass at my local grocery store. So I don't know, are they just talking about a can of beer just on its own as opposed to being in a six-pack? Not really sure. Or just a single glass because it's not a bar, it's a liquor store. But they made a point of saying, well, it's cheap. And so that means it's easy for, criminals or those who want to do business with criminals to just come and hang around because it's inexpensive to do so. And it's basically, if you stay there long enough, you're going to be able to make contact with somebody who wants to do something illegal or somebody who is on the illegal side that is looking for somebody, to make money off of. They filed, the city filed claims. Again, this is the people, right? So this is a criminal action. It's brought by the people. It's brought by the state to try to get this activity stopped. There were certain specific laws that were mentioned. The trial court granted summary judgment, said, yeah, okay, liquor store, you have to hire guards, you have to stop selling single-serving containers, cheap single-serving containers of alcohol, and you have to take some other actions that were suggested as part of the ruling. Went up again to the appellate court. The appellate court said, you know what? The evidence is all here. The people did a great job presenting their case. And the store owner knew, okay? The store owner was aware, okay, that third parties were using the liquor store for the sale of illegal drugs, that the store owner should have known it, and the store owner failed to take precautions that a reasonable person would have taken once put on notice of what they could do to try to minimize this activity. And so the the appellate court supported the summary judgment that was granted for the people. I threw in some quotes here. I like the one at the end of the paragraph, the appellate decision paragraph. We acknowledge the unprecedented character of this ruling. The parties do not identify a case imposing such a restriction, and we recognize that selling anything at a low price is typically a benefit for consumers who always like a bargain, okay? We thus confine our ruling to the circumstances of this case. Well, all rulings are really confined to the circumstances of the case. For the most part, you may see a Supreme Court ruling that intends to set a message generally, right? But where the low price of single alcohol servings was part of the constellation of facts creating the public nuisance, that the injunctive order was permissible in this particular case. You see, I've got another quote down there at the bottom. The appellate court was referring to another case called People versus Lim, and they cited something from the case that said, this pleading seems more from Dickens than from Whitkin. So I like the fact that there was creative parties, and I like the fact that there were creative appellate court justices. Michael, what do you say?
Again, excellent facts make for a appellate decision that's supported. I mean, that's it. That's what courts do. Apply facts to the law, right? But let's look at the law for a second, because I've dealt with this many times in my practice. So the essence of this law is Civil Code 3479. That's the basic nuisance law. And we got a lot of quotes here. So one of the quotes says, the doctrine of public nuisance is ancient, wide-ranging, active, and vague. Pretty broad, right?
Yeah.
And that's the essence of the problem with nuisance. And in court, it's all about the facts. The courts can do whatever they want. They're going to look at the facts. And in this case, they had so many facts, you know, of observations of the drug handoff, the guns, open till 2 a.m. I remember they had the hook, the person that basically is like the concierge or the waitress that you come up and you say what you want, and she goes in the back and brings you the drugs, I guess. So they had all of these facts. But when you're doing your cases, and nuisance comes up often, it comes up with neighbor disputes, it comes up with evictions. You know, whenever there's people, and people just don't get along, and they're doing something that they find offensive to each other. But 3479, yeah, it uses the word offensive. I once had an eviction where there were these two guys that, for whatever reason, the testimony was along the lines of every morning they would walk out of their apartment to get their mail. And one guy in particular tended to walk wearing nothing but a towel around his waist. And he apparently consistently, when he turned to walk back, would drop the towel. And the other neighbors found it very offensive. And I had a lot of neighbors testify, and we ended up evicting this guy. I think we evicted him too because during the trial he became rather aggressive, and the court saw that. But what's offensive to the senses is pretty broad. What's indecent, you know, we have all of our what's pornography, right? We've learned, but it's really important, you know, it's to get your facts straight. Okay, quotes. Okay, you got some good quotes there, Neil, but you omitted my favorite quotes from the case.
Oh no, okay. Go ahead,
Okay.
tell us, Michael.
Scroll down a little bit after the nuisance, and here's a quote. A scholar asked, why is making obscene telephone calls like laying manure in the street? Answer, in the same way as importing Irish cattle is like building a thatched house in the borough of Blandford Forum, and as digging up the wall of a church is like helping a homicidal maniac to escape from Broadmoor. All are, or at some time have been, said to be a common public nuisance. Okay? That was a pretty good quote. I like that one.
That was pretty good. It was a little too esoteric for me, Michael, which is why I didn't include that one.
Okay.
To me, I like something that you talked about before about how far back nuisance goes. And I like the fact that the court is looking back and it says, well, nuisance goes back to the 1300s. How often do you get to cite a case that's talking about something that is 700 years ago, right? That doesn't happen all that often. What gets me about this case, Michael, though, is the court could say all it wants, that they're confining the ruling to the circumstances of this case. But you could look at this case and it says, guess what? The people have broad authority to try to limit illegal activity, even if that means imposing restrictions on some entity, a store owner, that is not in and of themselves conducting that activity. But the fact that they are allowing it to happen, right? We are living in an area where living in a time where law and order is getting a lot of attention in the media, no matter where you live, in California or throughout the United States. Law and order is getting a lot of attention. And this is giving government a great deal of authority to impose upon property owners to try to minimize violations of law and order.
I also think property owners have to be careful. In this opinion, they had another statement of the law, like what they think the law is, and it said the reason to know standard is recklessness, not knowledge. Okay, you can't close your eyes to what's going on. So they're saying, okay, you can say you didn't know what's in the bag, and that's kind of a standard criminal code issue. Like, but being reckless
And
is
so,
what's likely in the
I
bag.
look at this case and I think about the other case that we were talking about, the takings case, right? When can a government, right, try to shift a government responsibility onto an individual without necessarily paying for it, right? That was kind of the issue in the takings case. In the Sheets case, well, there's this burden of overpopulation or increasing population. As a government, we're responsible for making sure we've got proper infrastructure, et cetera. How much of that burden can we impose upon individual owners that may be doing building, as opposed to raising taxes on everybody in the community? And here, the government is given authority to place some burden on an individual, right? On an individual property owner, a store owner, a business owner. Doesn't have to be a liquor store. It could be something else. Those of you who have clients who have businesses, and maybe that business is attracting, right, improper activity, you need to be concerned about this case.
Yeah, it's kind of like what we talked about in the other case, but now they're, to mitigate the harm to the community, hire security guards. And like they said, you have to stop the store being a snack bar for illegal drug buyers.
All right, so let's go on then to our next case. We got In Ray McKee versus Anderson, and this is a federal appellate case, a Ninth Circuit case, rose out of a bankruptcy issue. You had a couple. They were not married. They bought a house together. They also bought it with one of the parents of one of the couples. Lo and behold, the relationship soured. One of them moves out. The one who moves out said, I had to move out because I was being subject to abusive behavior by the other one. The parties eventually reached some kind of an agreement where it appears to be that there was going to be a buyout at some point in time. It's not clear when that buyout would happen or if it would ever happen, but it seemed that the expectation was that the one who moved out would be bought out by the one who remained. Well, years later, the property didn't sell. There was no buyout. The one who moved out is still entitled to the property. The one who moved out is having troubles financially, files for bankruptcy, wants to get the homestead protection in the property that that person no longer lives in. And there was an objection by the remaining owners, the partner and that partner's wife, and there was also an objection by the trustee. I'm making an assumption, I'm not a bankruptcy attorney, I'm making an assumption that the reason there was the opposition, which is those parties who were still in the property did not want the property sold and the proceeds distributed. They wanted to keep living there, right? And the trustee wanted to preserve as much assets of the estate rather than having it go to the partner who moved out and have that money be protected according to the terms of the homestead laws. The bankruptcy court sustained the objection. The bankruptcy appellate court affirmed. McKee, who moved out, appealed up to the Ninth Circuit Court of Appeals. They said, well, we need to look at state law, right? We were talking about federalism. We need to look at state law here. What is state law? What is a homestead? A homestead is designed to protect a principal dwelling in which the debtor reside. Here, McKee does not reside in the property, has not resided in it for years. And even though McKee stated that she would move back once the other partner moves out, wow, that's pretty indefinite. And then McKee also took steps to change her principal place of dwelling, right? She changed the address on her driver's license, and she changed her address for voting records. So the court said, guess what? You are not entitled to the debtor protections that are given for the homestead protections that are given to what would be really a debtor in possession. McKee made some interesting argument that's saying, well, wait a minute, there is this overall goal to protect victims of domestic violence. That should be taken into account to give me protections of the homestead. And here you have the Ninth Circuit that said, that's not our responsibility. The duty of the federal court, right at the bottom of your screen, is to ascertain and apply existing California law, not to predict that California may change its law, and then to apply the federal court's notion of what that change might or ought to be. So many people think that the Ninth Circuit is this liberal circuit and would never come up with a conservative decision. When you look at the language in this opinion, say, you know what? They took a fairly straightforward but conservative interpretation of California law. Michael?
Okay, so this whole homestead exemption thing is kind of technical. It's technical in the bankruptcy situation. It's different for divorces. You have to look in that, I think it's CCP like 704, that section. And there is a concept of portability, and there's a difference between if you have a implied exemption and the declared exemption where you have a document that's recorded. And there's an issue about because what happens, sometimes people sell their house and there's a gap between when they sell their house and they buy a new house, and are the proceeds protected or not? So this is a really, it's an area that people have to be careful and look into it, look into all the little explanations that they have, for the law here. But like the decision said, it's designed for where the person lives. You can go away. I mean, I remember there's some bankruptcy case about, like, if you go on a vacation and then your spouse files the bankruptcy while you're physically gone. There's like a bunch of stuff about that, but it is kind of technical, and bankruptcy lawyers are the ones that are really experts on this.
So there could be a legitimate intent to return, but it's going to be very fact dependent, and you can never really relinquish your claim to be residing in the property in the first place. And the court said here, McKee really relinquished her claim by saying there was going to be a buyout, changing the address on the driver's license, and changing their address for purpose of voting. All right, we're going to quickly go through our last case, Tucson versus Seattle. It's case very relevant to, again, what's going on in the news today. It arises out of Seattle, where somebody wrote language, some would call it graffiti, some would say this is just an element of free speech. Tucson wrote the words, peaceful protest on a temporary wall. Tucson was subsequently
Wait,
arrested.
but Neil, which wall
Yeah.
did you write it on? It's important. Where did he write it?
Outside the Seattle Police Department. East Precinct, yes. Yes, absolutely. So the police department obviously did not think very highly of that. They arrested Tucson, they arrested some others as well, but Tucson is the main plaintiff in this case. Okay. They did it pursuant to a state law, a city ordinance. That ordinance was subsequently amended. Remember, Tucson was never charged. The prosecutors did not pursue charges against Tucson, even though the police did arrest Tucson in this case, right? So no charges filed. The city winds up amending its law, and Tucson, who had a lawsuit challenging the law, was allowed to keep the lawsuit in place regarding the revised law. Again, Tucson never charged with anything in this case, right? The court goes on to discuss, whether there's a First Amendment right to conduct this. Is the law overbroad? Is the law vague? So in my favorite quote here, the Ninth Circuit says, well, guess what? Even when the law implicates First Amendment rights, the Constitution must tolerate a certain amount of vagueness. Again, something that many people would not typically expect from a Ninth Circuit opinion, right? But why do I bring this up? This is the First Amendment case. What does this have to do with real property? Well, part of this law, right, makes it a violation. A person is guilty of property destruction if they, A2, up there in the middle of the screen, write, paint, draws any inscription, figure, or mark of any type on any public or private building. And this reminded me of a Real Property Journal article that was written by the co-chair of the real property section when I was co-chair, that deals with intellectual property rights and real property. What happens when graffiti is placed on the outside of a building? And what happens if there is consent to that graffiti? So it's not really graffiti anymore. You distinguish between graffiti and some kind of drawing. And so this case reminded me of that article. For those of you who have clients who have property, there's writings on it, maybe with permission or maybe without permission. I suggest you take a look at the California Real Property Law Journal, volume 37, number 2 in 2019. And I gave you the link to get to that article to find out more about it. Michael, anything you want to say before we go on? Because we have a guest who's waiting to talk to us.
Well, I'll just briefly say something. One, I know of some new fancy apartment buildings where they have something called like the graffiti wall, where they're inviting people to write, I guess, whatever they feel like. This is going to lead into free speech. What's the other word? It's what's offensive. There's like a lot of stuff there. But my quote from this case, and we'll go, is I really like the analysis where they said about the preliminary injunction. They didn't like the way the court did their analysis. They're being very, I don't want to say hypothetical, but what they said there is that instead of examining whether the local ordinance is not vague, and the definition of what's vague is, it has to be like clueless, right? They talk in here, what's unconstitutionally vague is if it does not give a person of ordinary intelligence a fair notice of what is prohibited, right? Ordinary intelligence. What is that? IQ of 65? I don't know. But they said that the district court instead speculated about possible vagueness in hypothetical and fanciful situations not before the court, such as whether the local ordinance criminalizes signing a guest book or drawing in the sand on the beach, okay, or marking public utilities on the street. Okay, so again, it's the facts. You have to make your facts clear and relevant to the ordinance that you're trying to have the court interpret.
And the court does not really like to go beyond those facts if they don't have to. Okay, so I'm going to go now to our next screen. We always like to tell you what's happening with the real property section, and something that's happening. Again, if you want to write an article, again, great article in the Real Property Law Journal that I just cited on our last screen. But what's coming up tomorrow? What's coming up is real estate transactions in Indian country, sort of Indian country 101. You never know when this is going to involve you. I happen to be an arbitrator on a case, and the property involved in that case wound up being sold to an Indian tribe. So you never know when something involving I don't know the right word, but I'm sure Michelle will tell us. When an Indian tribe, will somehow be involved, because there's a lot of real estate in the state of California that is owned by or under the operation of an Indian tribe. So why don't you tell us about this class that you're going to have tomorrow, Michelle?
Yeah, thanks, Neil and Michael. We are offering through the California Lawyers Association a 1-hour MCLE tomorrow. It's in person in Sacramento and also online. And I am hoping that I can deliver 29 slides. Hopefully I can get through them all. I'm going to try my best, but I've been practicing in the Indian law field for 25 years, and this is kind of my master class. And it's going to bring together some background, some history, because it is important to understand that this is all Indian country. Every inch of California was originally used by Native people in California, and unfortunately was all taken away. And so tribes have retained some land, have reacquired land, and are actively working in the marketplace to acquire lands through purchase and through donation. Local governments, cities, counties, and the state and different agencies are also doing land transfers to tribes, because there's a lot of land in the state of California that was taken but was never really used or taken care of very well. And so many land return projects are underway right now, and I'll explain a little bit of that. But really, I'm going to focus on some of the meat and potatoes issues of Indian law, which is tribal sovereign immunity, jurisdiction over a contract, and the kinds of rules that apply when a tribal nation is as a negotiating party. So hopefully people learn from it, and we have the more people that know about it, the better.
Absolutely, Michelle. I've got a question for you. When I first saw the advertisement, it said, 101. Is this going to be one seminar in a series, or is this just one and done?
We're hoping to have a few opportunities to learn about Indian law issues related to real property. And if you all remember, I think probably every lawyer, their first case that they read in law school in real property was what? Johnson versus McIntosh. And Johnson versus McIntosh is not a case it's a case that Native people don't like, but it says that there was a doctrine to discovery and they could take the land. And so I mean, that's an easy glib way to look at it, but that's essentially the holding. And so real property law is built on that framework, and today tribes are still here. So we want to have this 101, and then maybe some more targeted, focused on specific kinds of transactions, so that we can take what we learned in the first one and then see how it played out in real life.
And so you don't have to be an Indian tribe or Native American practitioner to get value out of your class, right? Somebody who maybe has never experienced any kind of contract or involvement, would they get something of value by going to the class tomorrow?
I hope so. I hope a lot of people are curious about what the issues are when you're dealing with an Indian tribe, because I know a lot of the problems, the cases that end up in the courts are where lawyers didn't know what they were doing. Pretty much, where they just didn't understand the framework. And so it gets them into problems in their contracts, and it gets them into misunderstanding whether the tribe has a right to do a particular thing, such as can the tribe lease their land, or do they need the federal government, the Bureau of Indian Affairs, to approve it? So yes, any person that works in the real property sphere could encounter a Indian law transaction or a transaction involving a native person or an Indian tribe, whether you work for a city or a county. Those also come up. I interface with all kinds of practitioners, and the more that real property lawyers know, I think the better our transactions will be for everybody.
Okay, so it's going to be live. If somebody wants to see you live, you're going to be in Sacramento. Where are you going to be?
We'll be at the California Lawyers Association office on Capitol Avenue. Not sure.
Okay, great. And it's from 12 to 1. And if you're not able to make it to live, you can register for the webinar. Just go into the CLA, go to the real property section, go to education, and you could register for the class. Thank you for joining us for a few minutes today, Michelle. We really appreciate it.
And
Yeah.
Neil, I just put the link in the chat if anyone wants to click the link in the chat and register for the webinar.
Oh, thank you. And we're going to talk for just another minute or so people have a chance to look at that link. Thank you. Thank you very much, Brooke. I'm going to, here we go. So if you've got a question, a comment, you've got something that you think Michael and I should discuss, you think you'd be a great interview candidate, contact either me at neilk@car.org or Michael at simkinlaw.com. Remember, as of January 1st, these What's Up With Us webinars are available for 1 hour of self-study MCLE credit, and you should be getting a certificate. And Brooke, do they also get a copy of the presentation, a PDF copy of the presentation?
Yes.
Yes, you do. Okay, will that go out tomorrow or will it go out later next week?
It should go out tomorrow by end of day.
Okay, so look forward to your email and keep track of your credit. That's all for me. Michael, why don't you close us out today?
Oh, well, I was very happy today to revisit constitutional law. That was always one of my favorite classes. So thank you for bringing those cases to us.
Thank you. We'll see you next month, June 20th. Bye, everybody.
Bye.